Good evening, students. Today we are going to start our next topic, which is mode of transfer. So, as in the previous lecture, I have told that there are two types of doctrines, and we have discussed both of the doctrines. The first one was doctrine of election, and the second one was doctrine of lease pendants. Now we are going to study about modes of transfer. So, what is mode of transfer? Actually, for transferring, there are different kind of modes by which we can transfer the immovable property. So, in that context, in your textbook, there are 4 types of modes which are given. The first one is sale, the second one is lease, the third one is exchange, and the fourth one is gift. Now, we are going to study about sale. That what is sale? What is sale of immovable property? So, as I have written here, that according to section 54 of Transfer of Property Act, again I am saying that according to section 54 of Transfer of Property Act, sale means transfer of ownership. Sale means transfer of ownership in exchange of price paid or promised, or partly paid or partly promised. In another word, you can also say that in a sale there exists an absolute right, means in a sale there exists an absolute transfer of all the rights in the property which is sold. Means the property which a seller is selling. So in that property, the buyer will going to have the absolute right. So again I am explaining that according to section 54, sale means transfer of ownership. Students, you have to understand it very carefully that in sale, ownership is being transferred. Means ownership of the immovable property is also transferred in the exchange of price paid. Means whatever price is being paid, means in terms of money, whatever the consideration has been paid, in exchange of that, the ownership is transferred to that person who has bought the immovable property. There are two parties in sale. The person who is selling the property is known as seller, and the person who is buying the property is known as the buyer. As for an example, likewise, X want to sell a house. X want to sell a house to B in rupees 2 lakh. Then X will become the seller. The house is the immovable property. B is the buyer. And the amount 2 lakh rupees is the consideration, in the exchange of which the house is being sold. So hope you have all understood that what sale exactly means. So in this property, when X will going to sell the house to B, B will enjoy absolute right. means this property will become B's property and B will have the complete ownership on this property. Again I am saying this point is very important, that in sale there is a transfer of ownership. There is a transfer of ownership in exchange of price. Now coming to the elements of the valid sale, it is same like what we have earlier discussed in the Contract Act. In the contract, that there are certain essential of a valid contract. In the same way, there are certain elements in sale, in a valid sale. So moving to our elements point, the first and the foremost element in sale is the parties. The parties. There has to be two or more parties in the sale, without which a sale cannot be done, means a seller and a buyer has to be there. Now, secondly, the property to be transferred should be in existence, means the property which is being sold has to be in existence, means subject matter has to be present, means the immovable property has to be there. It should not be a fictitious transfer. And the third one is the consideration should be in the form of money. The consideration should be in the form of money. There are two instruments by which the sale is being done, and those two instruments are through which the sale is being done is the registered sale deed, means registry is very important. Registered instrument has to be there. If the sale is of the value more than rupees 100, then there has to be a registered instrument with the signature of two witnesses. Hope you have understood this. Now moving to our next point, which is rights and liabilities of seller and buyer. Here I have written rights and liabilities of seller and buyer, but in the point I have mentioned liabilities first and the rights after that. So we'll discuss the liabilities of the seller first of all. There are certain liabilities of seller. Liabilities, you can, in Hindi you can say dair. What is the liability of a seller? So firstly, the seller, I'm only discussing few of the liabilities. The rest of the liabilities you can just go through the textbook and find out the rest of the liabilities given in the textbook. So in this, the liability, the first and foremost liability of a seller is disclosure of the defects of the property. Very important. The seller has to disclose whatever defect is there in the property which he is selling. Now, the second liability is produce all the documents which are related to the title. All the documents which are related to the title, or you can say ownership, has to be produced before the buyer. Before the buyer by the seller. In the same way, there are certain rights also for the seller. So those rights are, I have explained one. Just go through the rest of the rights from your textbook. The right is, the foremost right is claim the amount from the buyer. Means after selling the property, once the registry has been done, then the seller has the right to claim the amount of consideration from the buyer. Again, I am saying, after selling the property, means after registering the property in the name of the buyer, the seller has the whole right in claiming his consideration amount. Coming to the rights and liabilities of the buyer, they are almost similar to the rights and liabilities of the seller. Buyer has the liability while he is purchasing the property, then he has to pay. First and foremost, the liability of the buyer is he has to give the money to the seller before the completion of the sale. Means when the sale is being completed, then it is the liability of the buyer, to give the consideration amount to the seller. Now the second point is, buyer also have to pay all the public charges, rent, after getting the ownership. Means once the ownership has been passed to the buyer, then he is liable to pay all the public charges, all the rent, taxes, and whatever it has been there. So hope this point has been clear. Now there is one right. There are several rights. Just go through the book, go through the textbook for those rights. I have explained one, so I want to tell you this right, that the buyer has the right of compelling the seller to give the registration deed, or you can say to compel the seller to sign the registered deed. After giving the consideration amount, buyer has the right to get a registered instrument signed by the seller. Now we are going to discuss this case, Madam Pillai versus Badar. So in this case, it has been said that plaintiff was the wife of the defendant, and she claims that the husband has executed the transfer. Means the husband has transferred the property, immovable property, which was of the value of ₹100 orally to the plaintiff. But afterwards, the defendant had refused. So in the case, the court had held that the plaintiff will going to acquire the title by way of oral transfer, and she is entitled to the property through the instrument of sale. In section 54, it is itself written that property which is valued, under ₹100 or 100, the property can also be orally transferred. But for each of the property which is more than the value of ₹100 can only be transferred through a registered deed or you can say through a registered instrument. Hope you have all understood the present topic. In the next lecture, we are going to discuss our second mode of transfer, which is lease. Thank you.